Okay, great. My name is Alex Abdo. I'm the litigation director at the Panelists Institute, and we'll be discussing surveillance at the border and surveillance across borders. And as I'm sure you've gathered over the course of the day, the border is, though not quite a law-free zone, certainly one where ordinary legal constraints on government power have given way to notions of sovereignty and exclusion. One particular consequence of that treatment of the border by governments is that surveillance at the border and transnational surveillance across borders has gone relatively unregulated. That's the phenomenon that this panel will be covering, and we have an incredible panel to do so. You can see the fuller bios in your packets, but very briefly, let me introduce who we have with us. To my immediate right is Ashley Gorski. She is a senior staff attorney in the ACLU's National Security Project, where she has litigated enormously important cases related to privacy, government surveillance, racial and religious discrimination, free speech, and she was one of the lawyers who worked on the case that Catherine and Jamil mentioned, challenging NSA surveillance on behalf of Wikimedia. To her right is Ron Deibert. He is the founder and director of the Citizen Lab at the Munk School of Global Affairs and Public Policy at the University of Toronto, where he is also a professor of political science. And to his right is Jaya Ramji-Nogales, who is the associate dean for research and the I. Herman Stern research professor at Temple Law School, where she also supervises the Temple Law Asylum Project. So I'm going to start with Jaya and Ron, who have drafted essays for the symposium. I'll ask them a question and give them an opportunity to tell us about their contributions. But before that, let me just remind you that you should feel free to submit questions using the QR code behind us, or if you're in the room, you can also, or instead, feel free to use the microphone. It's not there at the moment, but if it comes back, you're free to use it. If it doesn't, just use the QR code. Great, so let me kick things off. So Jaya, let's start with you. You and your co-author, Nicole Ramos, who unfortunately couldn't be with us today, drafted an essay explaining how surveillance at the US border has been used to stifle the legal representation of migrants, and also to suppress the distribution of know your rights material to these individuals seeking to cross the US border. Can you tell us about what you've documented and why the law hasn't, at least of yet, been of help?
Thank you, Alex, and thanks so much to the Knight Institute for hosting us today. So in our paper, we're really interested in the availability of First Amendment rights on the other side of the border, al otro lado, in Mexico, for US citizens and non-citizens with respect to actions by US government officials, primarily US Customs and Border Protection, and by Mexican officials acting in concert with CBP. So if you can think of this as a matrix, you could see that the applicability of the First Amendment will be most obvious for US citizens interacting with CBP and hardest to enforce for non-citizens with respect to Mexican officials. Our essay, we're really focused on border lawyering, so the provision of information about legal rights and processes to undocumented migrants in Mexico. So about legal rights and processes to enter the US for folks who are at the border in Mexico. So I'm calling it border lawyering because this can extend beyond lawyers, right? Know your rights presentations, accompaniment at the ports of entry, other activities that don't require someone to be barred as a lawyer in the US, but there are also some activities that are more limited to lawyers, so representation, legal representation at the port of entry in Mexico, and then subsequent litigation in the US to challenge activities at the border. So I'm really interested in the location, right, outside the US, the different actors, so we have a foreign government acting in concert with the US government, we have lawyers, some US citizens, some not, folks who are working with lawyers, and then they're working with undocumented migrants, right? So all of these, I think, are going to impact the First Amendment analysis. So as the border has increasingly become a site of encampment or warehousing, whatever you want to call it, and political contestation and theater, we've seen surveillance and harassment of border lawyering actors on the rise. So I'm really sorry that Nicole cannot be here to present. Hi, Nicole, I think she's watching us. As these are really her experiences as a border lawyer for al otro lado in Tijuana. Nicole is a former student of mine. She is extraordinary, and she has been in Tijuana directing the Border Rights Project for al otro lado for many years now. So some of what she and her coworkers have experienced was under the Trump administration has been well documented, including official government reports, but also continues to some extent under Biden. So just one example of that is the CBP officials, that CBP officials under Trump created a database about the activities of U.S. citizens with respect to the migrant caravans coming north through Mexico. And so under the Biden administration, there was a First Amendment lawsuit challenging that database, and the Biden administration litigated that through to summary judgment, which they won. So it's not that there is a kind of continuation of the defense of the policies, at least. So there are a variety of methods of harassment that Nicole and her coworkers have faced. So it's clear, and this is clear in the DHS Office of Inspector General report, that CBP is working with Mexican authorities to deport border lawyers from Mexico. One of her colleagues was deported. She was on vacation with her family in Mexico. She was detained at the airport and deported. And then another colleague was prevented from entering Tijuana, even though her 10-month-old son was in Tijuana. So there's work there and holds being placed on their passport with the Mexican government. What they've also seen is officials, U.S. government officials, sharing information about them with private actors who then spread that information through right-wing nationalist media platforms. So this multiplies and amplifies the sources of harassment. And then they've also seen really ongoing surveillance by Mexican border officials, physical observation, photography, attempts to intercept conversations and infiltrate their offices, and then digital means, potentially an installation of spyware, an attempt to install spyware on their phones. I just want to make clear that I'm not a First Amendment scholar. I have a very good teacher in the audience here who gave me a very long reading assignment, including several cases he's litigated. So there's a lot of case law, but given the limited time, I just wanted to raise two cases. So first of all, U.S. v. Hansen, the Supreme Court last year upheld an anti-smuggling statutory provision that CBP has used to justify the surveillance and harassment of border lawyers. And the underlying Ninth Circuit decision held that the provision of certain legal advice to undocumented immigrants is protected speech under the First Amendment, striking down the statute as overbroad and unconstitutional. Of course, a very helpful finding that was then overturned by the Supreme Court. And then the Phillips versus CBP case, which I mentioned earlier, the database lawsuit under the First Amendment, that ends in summary judgment in favor of the government. So I'm somewhat less optimistic, perhaps, than others about the role of the First Amendment here. But Alex is going to correct that, I think.
Well, we should definitely jump into that. But before we do, let me just invite Ron to the conversation. So Ron, you and your co-author, Sienna Anstis, drafted an essay describing what you call digital transnational repression. Can you tell us what that is, why it's an effective form of repression, and, similarly to Jaya's description, why the law has been slow to keep pace with it?
Yeah, happy to, and thanks, by the way, to the Knight Institute for the invitation to come here and for you for moderating this panel. A couple disclaimers right off the bat. One is I'm Canadian, I'm not American. I had to cross a border to get here, and being the director of a security-conscious research lab that deals with very high-risk human subjects, it's quite an ordeal for me to cross any border, maybe especially this one. The other disclaimer is I'm not a lawyer. And I feel a bit out of my depth in some of this conversation. Sienna Anstis, my co-author, is a senior legal advisor at the Citizen Lab, and she really did the heavy lifting on this paper. So if you ask me any hard legal questions, I might have to invoke that other amendment of yours down here. So to transnational repression. Well, by way of background, for those of you who don't know, major focus area of the Citizen Lab, we are a group of investigators, researchers whose focus is on digital security issues that arise out of human rights concerns, constitute as a kind of counterintelligence for civil society is the way we think about what we do. Do a lot of forensic work, for example, and one of the areas that we've, I think, really pioneered is around detecting the abuse of very sophisticated mercenary spyware. This is technology that's marketed by firms to government law enforcement, intelligence agencies, in this case to infiltrate a target's device. And once inside a device, of course, it's highly revealing. They can find out, any communication, any email or text that have been exchanged, even those that are end-to-end encrypted, turn on the microphone, the camera, and so forth. And we've been doing this for many, many years. And it is one example of what we would call digital transnational repression. So transnational repression in the conventional sense, been around for a long time. It's basically about governments who reach across borders outside of their territorial jurisdiction to suppress dissent or chill political opposition abroad, usually these days involving refugees, immigrants, and others who have in many cases fled abroad for their safety to get out of the reach of those governments. And traditionally this has happened in many different ways, everything from targeted assassinations to abuse of Interpol red notices and other forms of harassment and intimidation. The digital component is really quite game-changing, I would say, for this area, and I think it does deserve a different category of its own. As I described with our research on spyware, what we're seeing is it's opened up all sorts of new opportunities for malicious actors to undertake surveillance or harass into silence people who are based abroad. So people think they leave their country, they're now in a country like Canada or maybe the United States, feel a bit more secure, and they find out, actually, no, I'm not, because the people that I have escaped are able to, in the case of mercenary spyware, actually get inside my device. And the latest, most sophisticated versions of this technology quite literally have no defense. So there is nothing a user can do to protect themselves from, for example, the latest version of Pegasus spyware manufactured by Israel-based NSO group. Going back many, many years, we started to recognize in the course of dealing with the victims of this type of surveillance that they were experiencing various forms of trauma, frankly. And we decided this is something that warrants further research. So we decided to set up a research project, a qualitative project, where we wanted to interview human subjects. And we're just about to publish a major report on this, where I and my team interviewed more than 80 individuals. This project has a particular focus on the gender-based dimensions of digital transnational repression. And what we've discovered is pretty consistent across these more than 80 individuals, regardless of the country that they have fled from or their particular experiences. They're very similar in terms of the effects that they have. Most importantly, a silencing effect. And it is really kind of common sense. So again and again, we're hearing from victims that whereas once, the internet was, like most people, kind of critical to their day-to-day life, or their mobile phone is essential for their activism, their advocacy, their professional life, whatever. Now, because of what they're experiencing, they're afraid to go online. They're unwilling to associate with members of their extended diaspora. They no longer have social media accounts. They've effectively been harassed into silence. And that's where I think the connection to the First Amendment really comes in here. We're clearly seeing in the course of these interviews the profound impact it's having on people's ability to associate and express themselves.
Thanks, Ron. So let me turn to Ashley, and then we're going to dive into each of these papers and areas. But Ashley, before we get to that, maybe you could tell us first, why and precisely how you lost the Wikimedia case. No, I'm just, no, more. So you've litigated cases in both of these areas, and I thought maybe we could start with, the context that Jaya's paper raises. You've litigated a case relating to CBP's discriminatory questioning of Muslim Americans at the border. Can you tell us about that litigation and what guidance it offers to optimists like me who think the First Amendment can play some role in regulating government authority at the border?
Sure, and thanks, Alex, and thanks to the Knight Institute for having me today. So at the ACLU, we are representing currently 3 Muslim Americans, U.S. citizens, who, when they come back to the U.S., come home from international travel, they are stopped at the border, border officers take them into secondary inspection, and officers ask them questions like, how many times a day do you pray? Are you Muslim? Do you attend mosque? Are you Sunni or Shia? How religious do you consider yourself? These are questions that have absolutely no relationship to any legitimate objective that CBP could possibly assert. They are predicated on the false and harmful assumption that the practice of Islam is inherently suspect. We have a host of constitutional claims in this litigation. Most relevant here, we are arguing that these questions violate our client's right to free association because they're compelling disclosures about our clients' associations, about the mosque they attend, about whether they are Sunni or Shia. And those questions have to satisfy, under Supreme Court precedent, exacting scrutiny, which requires the government to show that the questions are narrowly tailored to an important objective. And the government can't meet that burden here. In addition, one of our clients was very clearly retaliated against for his protected beliefs and his speech invoking his rights at the border. He was carrying a religious journal, and as soon as the officers saw the religious journal, they began intensifying the scope of their search. They asked additional religious questions. The stop was extended. He was basically penalized for invoking his rights and for being Muslim. And during the first panel, there was some discussion of First Amendment retaliation. Again, this is a clear instance of retaliation against an individual for their protected beliefs and protected speech. So one of our arguments in this case is that the First Amendment applies at the border without exception. These are US citizens. I think that makes the argument even clearer. And the government hasn't really disputed that point. Now, the government has invoked its broad authority under the Fourth Amendment. There's a lot of very problematic language in a lot of cases about the government's authority at the border to search people. And there is a narrow exception to the Fourth Amendment's warrant requirement at the border. But there's no comparable exception in First Amendment doctrine. The First Amendment applies with full force, and the government really hasn't argued to the contrary. Unfortunately, the district court dismissed our case last year, but just this month, the Ninth Circuit Court of Appeals reinstated it, so we are moving forward to discovery. So there's a lot of reason for optimism and for hope here. Yeah.
Can you tell us about the Ninth Circuit decision, and does it, I don't know, does it give you hope that you'll win on the substantive question, or was it a procedural ruling?
Well, it was a very strange posture. So in the district court, the government made a host of arguments with respect to each of our constitutional claims, saying we hadn't stated a claim, and the district court unfortunately agreed with the government on that count. On appeal, the government's only argument essentially waived and abandoned its other arguments. Its only argument on appeal was that we had not shown a pattern or practice of discriminatory religious questioning, so it was a kind of procedural argument. And that was clearly not going to be a winning argument. We have 3 clients. They were subject to this questioning on 10 separate occasions. There's extensive documentation in government reports of dozens of other Muslim Americans being subjected to similar religious questioning at the border. So it was a clear case for us, and now the case will go forward.
Great. So let me turn back to Jaya for a minute, and but anybody can feel free to jump in on the question. I guess when I read your paper, one of the reactions I had was it seemed to me that there is a fact pattern here that might present a great opportunity to give a court a chance to articulate First Amendment protections that might actually do some good work. And I wonder, if you, in working with Nicole and hearing about the kinds of experiences that Al Otro Lado is experiencing at the border, could come up with that fact pattern, could come up with a test case to build the kind of First Amendment protections you want to see. What would that look like?
Yeah, it's a great question, and I think, the main thrust of my answer is just more clarity, right, about these questions about extraterritorial application, U.S. citizens, non-citizens going through Mexican government officials, and the applicability to the provision of legal services or legal advice, know your rights information to undocumented migrants, right? So kind of that intersection. And so that's where it would be really helpful to see clarity. So, for example, a US Supreme Court decision that clearly says the First Amendment applies abroad, right? So we have all of this contestation about that question. So Reed v. Covert tells us the Bill of Rights protects US citizens abroad, but some speech falls outside those protections, right? A clear and direct threat to national security. And so that makes me concerned about these anti-smuggling statutes, right, from US v. Phillips, and the framing of migrants as national security threats, and then kind of the unspoken role of race with respect to national security, right? Who's a national security threat? Oh, of course, it's these migrants trying to come in from Mexico. So it would be helpful to have some clarity there. And also, of course, the federal courts have found no First Amendment right of association or speech where the migrant has no underlying legal claim. But like, you know, how far does that extend? It would be really helpful to understand what that is, because of course, as lawyers, right, you're going to present that asylum claim even though you know that you know it's a 30 to 40% recognition rate. So does that mean they have no, who decides whether they have no legal claim? How far does that extend? And so I guess I would start by pushing for recognition of the right of US citizens to offer legal services to undocumented migrants outside the US. And, you know, I think in terms of remedies, you want the litigation to change the practices of CBP, right? Which is a really, really hard nut to crack, right? So just thinking about training that can be implemented, consequences that can be implemented to try to shift the culture of the organization, right? Which I think you need to really think creatively about how litigation can do that, and then thinking about lawsuits against individual officials, possibly, and the uphill battle against qualified immunity. Another place that I think would be helpful to see some clarity is collaboration with Mexican officials and how the First Amendment plays in there, right? There's a lot of obscuring what's happening, but right, thinking about whether the U.S. government is required to protect U.S. citizens' right to speech outside the U.S., or at least not to collude with foreign officials to limit their speech rights outside the U.S. And then, yeah, just thinking about through the battle between anti-smuggling statutes and the First Amendment, how to constrain the carceral approach to migration. And I will say that if I'm even less of an expert in the Fourth Amendment than the First Amendment, but I just want to note that the U.S. is making Mexico do its dirty work, right, by putting the names of border-lowing actors on this list, on this passport hole, so that it's the Mexican government who's detaining and deporting people, right? So also just thinking about all of that and how to get, so it's a lot of questions, and it's maybe not one litigation, right? But I think there are a lot of places where we could just use more clarity in the law, you know, in a good direction, which is an awfully optimistic thing to hope for, I think.
Ashley, what do you think? Do you think that, you know, your litigation provides a framework for establishing some of the rights that Jaya is talking about?
Well, the litigation is on behalf of U.S. citizens. We do have an expungement claim, which is similar to the claim that was at issue in the Phillips litigation that you were discussing. That's not our only claim, though, in part because our plaintiffs can show that they're going to be subject to the questioning again. And I think that one of the challenges in these cases is that oftentimes it's clear that there has been historical government misconduct, but there are legal doctrines that make it very difficult to sue the government actors for their historical misconduct. And then if you're trying to alter training practices, if you're trying to get some kind of remedy going forward that would change the government's implementation of its policies, you have to show that the injury is ongoing, it's likely to recur, and then litigators have often relied on these expungement claims in cases where they can't necessarily show that they're going to be subject to the unlawful conduct again. They can say, but my information, or my client's information, is in a database, and the government's retention of information in that database is an ongoing harm because the information was unlawfully collected, and it could be used against me in the future in all kinds of ways. And that in itself is an ongoing harm that merits a remedy that's forward-looking. But it can be very difficult, and the Ninth Circuit's ruling, unfortunately, narrows the set of circumstances in which those types of expungement claims are available to litigants.
Thanks. So let me turn back to Ron for a second. So Ron, I'm hoping we can focus on spyware for a second as one of the mechanisms of digital transnational repression that your paper discusses. And this actually aligns with one of the questions that just came through on the QR code. I'm hoping you tell us, answer a couple of questions. One is, to what extent has law been, and I'm mindful of your disavowal of legal knowledge, but to what extent has law been effective at holding the use of spyware, especially the abusive use of spyware, to account? And full disclosure, the Knight Institute is litigating a case against NSO Group on behalf of 18 members of a Salvadoran newsroom who were targeted using Pegasus spyware, with the NSO Group's spyware, based on the Citizen Lab's investigation and in close collaboration with you all, technical expertise and consultation. So can you tell us a little bit about what you've seen internationally in efforts to hold the use of spyware accountable? And then I also want to just dig in a little bit to one thing you said. You said it emphatically, there is no defense, or we have no defense against spyware. A lot of people will see a technical problem and look for a technical solution. And so from your vantage, you are a technical expert. Why isn't there a technical solution? Why isn't there more that we can expect from our phone manufacturers, from technologists defending against those kinds of attacks?
Yeah, those are both really good questions. So I may not be a lawyer, but I've been surrounded by lawyers for the last 10 years. I feel like I've gone through kind of law school by osmosis. Learned a lot too about litigation, and both the pros and the cons actually. And I can speak to it both in terms of holding companies accountable, but also as a research group like ours, some of the experiences that we've had being even a non-party to some of the litigation, but because of the work that we do is sometimes the evidentiary basis for some of the litigation that's going forward. We actually, for those who are interested, on the Citizen Lab website, we actually keep a updated list with links to as many of the documents as we can find of all of the cases of litigation involving not just NSO Group, but all of the other surveillance vendors that are in this space. I'd say the overall, the picture is a bit mixed. I think it's very important that victims have a pathway to justice and accountability, and typically that has to come through exercising some legal avenue of redress. The problem is, well, there are many problems. One is that often it's the case that the court will say, well, this is the wrong jurisdiction, or they can't demonstrate the harm occurred in this jurisdiction. There's that, and in some other cases, I think, well, we just had Apple announce that they're withdrawing their lawsuit, which is interesting. I can understand some of the justification that they made for it, but I know it's also disappointing for some people who want to hold that company responsible. I think what ultimately needs to happen, though, to really deal with this issue, and actually this is broader than just spyware, it has to do with digital transnational repression as a whole, through social media, through the internet and other means, is to start building a suite of responses. And maybe in some cases, again, I'm not a lawyer, but I know some people have recommended that countries could pass legislation making it permissible or okay, whatever the language is, for someone to sue a foreign government in their jurisdiction. And I know there's been some promising developments in the United Kingdom around that, for example, recently in some cases involving the countries that were operating the spyware. Same could hold true around the manufacturers of the spyware. Perhaps I'll answer this in a later round, but maybe ironically, the United States government has actually gone the furthest in quite aggressively dealing with digital transnational repression. A variety of legislative, institutional, punitive measures have been taken, but at the heart of it, I think there's a contradiction and a tension, which we can talk about later. With respect to the technical question, look, there are a couple of things at work here. One is that we have highly paid, highly trained engineers who come from some of the world's most elite signals intelligence agencies. In the case of companies that are affiliated in one way or another, connected to Israel, These are veterans of Unit 8200, extremely talented engineers who have a lot of resources, and all they do all day is look for some exploit that they can use as an anchor to then implant spyware. That's against a digital ecosystem whose prominent characteristics are invasive by design and highly insecure. Security is largely an afterthought. You know, the business model is to move fast and break things. And that's principally why you have this situation where the technology is advanced to such a level, the latest versions are known as zero-click. In the past, in order to activate spyware on someone's device, you'd have to trick them into opening an attachment or clicking on a link, and that would activate the exploit. Now that's not necessary at all. You can fire an exploit at any device anywhere in the world, and because the manufacturers of the operating systems of those devices are not aware of the vulnerabilities that are being exploited in those systems, they're sitting ducks. So, you know, you don't need to take my word for it. If you look at the latest version of Pegasus that we at the Citizen Lab captured and did a responsible disclosure to Apple and Google, both of them came out and said, while this was active, there was literally nothing anyone could do to fix the problem.
Do you have any hope that we would, at some point, end up in an ecosystem that is capable of protecting users from those sorts of threats, or do you think that that there's something inherent to the cat and mouse game of digital offense versus digital defense that always favors the attacker, or the economic incentive?
It's a kind of systemic feature of the landscape. It's going to be very difficult to reverse. For example, what I describe about the ecosystem being invasive by design and highly insecure. Those are not just surface characteristics. That's a representation of the business model of social media, of surveillance capitalism. So, you know, you need to fix that before you could fix the underlying problem. It's very daunting to think about fixing that. However, it's not entirely bleak either. I think, again, the United States has actually led the way in holding accountable firms that are associated with digital transnational repression or human rights abuses through sanctions. NSO Group, a variety of other firms that we and others have uncovered have been put on the designated entity list. Individuals have been sanctioned. That's like, I wouldn't have believed that 3 years ago that would have been possible, and now it's happening. And there are at least normative guidelines. There's I would say a regime that's starting to develop internationally. 21 governments have pledged to do something similar to the United States. None of them have. We hope they will. But those are promising small steps, I think. So we shouldn't get discouraged by the seeming futility of the big picture. There are little things that we could do to help in the meanwhile.
So I want to turn back to Ashley for a second. One of the arguments that NSO has made in all of the lawsuits that have been filed, I think all of the lawsuits that have been filed in U.S. court against it, at least 2 of the 3, is that these are cases that don't belong in U.S. court. They belong perhaps in the Israeli court where NSO is based, or they belong in the courts of the jurisdictions where the victims live. I'm not aware of anyone trying to sue NSO in Israel, but imagine a parallel suit here. Imagine that it was a foreign victim of U.S. Surveillance by, say, the U.S. government or U.S. government implicated surveillance. We're trying to hold the U.S. government accountable for that kind of sophisticated technological surveillance. We don't have an example quite of the U.S. government's use of spyware, but we do have your litigation against the NSA. Can you tell us a bit about how hopeful you would be for the prospect of law being a meaningful mechanism of accountability? I mean, maybe you can start by telling us about the Wikimedia case that we've alluded to a couple of times today, how that turned out, and whether there's any, whether you have hope for the next case turning out differently.
Well, I think in your hypo, the plaintiff would be a foreign person. Is that right?
Yes, but let's suppose you can get over that. Get over that part.
Okay.
And suppose they have rights to assert in a U.S. court.
Yes, if they have rights to assert in a U.S. court, I do have some hope, but litigation is uphill for the reasons I will explain. In 2015, the ACLU, later joined by the Knight First Amendment Institute, brought suit on behalf of journalists, human rights workers, lawyers, and Wikimedia, which hosts Wikipedia, everyone's favorite internet encyclopedia. And this was a suit challenging a form of warrantless NSA surveillance of Americans' international communications. Unfortunately, Catherine spoiled the ending here. The suit was, and Alex at the beginning of the panel, the suit was not successful. We litigated for 8 years. We did not prevail, and this surveillance continues under an authority known as Section 702 of the Foreign Intelligence Surveillance Act, or FISA. And to understand why this surveillance is so pernicious, why it's so controversial, it is helpful to have a little bit of historical background. So just very briefly, for decades, when the US government wanted to conduct foreign intelligence surveillance on US soil, even when it was targeting someone who was a foreigner abroad, it had to go to a secret court known as the Foreign Intelligence Surveillance Court, and it had to make a showing that its target was a foreign power or an agent of a foreign power. Now, after 9/11, the Bush administration just ignored these rules, blatantly violated the statute, violated constitutional rights, engaged in widespread warrantless wiretapping, other forms of warrantless surveillance. When this came to light, there was significant public outcry, and the Bush administration tried to put this warrantless surveillance on more of a legal footing. And one way in which it did that was to lobby Congress for the authority that became Section 702. Under Section 702, targets no longer need to be agents of a foreign power. The executive branch can target any non-US person abroad to collect foreign intelligence information, which is defined to encompass even information about the foreign affairs of the United States. There's no longer judicial review of targets, and even if there were, the standard is so low it would be effectively meaningless. Targets do not need to be suspected terrorists. They don't need to be suspected of any criminal wrongdoing. They can be academics, human rights workers, journalists, any ordinary person who's a non-US person located abroad. And at last count, there were more than 268,000 of these targets. They, of course, communicate with Americans. So the NSA, under Section 702, can capture all of these targets' communications, including their communications with Americans, without getting a warrant. And in the Wikimedia case, there were significant First Amendment harms to our clients. People who worked for NGOs were self-censoring in their conversations in ways that made it difficult for them to do their jobs. We represented lawyers who were having to make additional trips abroad to speak with witnesses and clients in person because they were concerned about their ethical obligations of confidentiality and concerned about the prospect of Section 702 surveillance of their communications. And for Wikimedia, we had empirical evidence that after the Snowden disclosures, after the public learned about the full scope of Section 702 surveillance, people were not reading terrorism-related Wikipedia pages. Catherine talked about the one example of someone she was connected with who described this for them personally. We had empirical evidence showing that this was happening at scale. There was a significant and sustained drop in readership of terrorism-related Wikipedia pages, in addition to a lot of anecdotal evidence where people were saying, I'm reluctant to edit these pages. I'm very concerned about Section 702 surveillance. I'm not engaging with the site in the way that I used to. And when you are talking about the world's largest encyclopedia, this enormous repository of human knowledge, that is a very real loss and a very real harm. But even with that harm, after years of litigation, the courts did not allow our case to proceed. It was ultimately dismissed on secrecy grounds. The Fourth Circuit accepted the government's argument that it could, in theory, have secret evidence that would defeat Wikimedia's standing showing. And in 2023, the Supreme Court declined to hear the case. So that was the end of the road for this litigation. I think one of the lessons here, again, is that litigation is uphill. It's not impossible, but elections matter, political mobilization matters, legislative reform matters, and elections matter because they affect the composition of the judiciary. But I think there's still some reason for optimism. Wikimedia 2.0. We continue to litigate in challenges to foreign intelligence surveillance, including in criminal cases, and that's part of the work that we do. But this case, it did have a disappointing ending.
I want to come back to that. Let me go to Jaya for a second. Actually, let me just come down the line. So if it turns out at the end of the day, and I'm too much of an optimist to give hope, for the law as at some point constituting an effective constraint on the practices that we're all concerned about. But if it turns out that law is not going to be, at the very least, sufficient, what would you like to see? So Jaya, for you, for border lawyering, what would you like to see if not clear legal constraints on CBP authority? What would you like to see? And Ron, what's a framework for regulation of spyware that you would like to see? I know many people have called for a moratorium because they don't believe in the ability of, or an outright ban because they're not confident that we could come up with a framework that would meaningfully constrain spyware. And Ash, if you were allowed into court, what would, if you could design a law that would get you around the problems that you face so far, what would that look like?
Yeah, great. Thanks so much. And I think I'm going to echo Ashley a little bit here. And I'm, with all due respect to the litigators in the room who do amazing things, I think litigation is not, even if litigation is successful, it's not the only answer, because I'm not a First Amendment scholar, but I spent a lot of time studying CBP, and that, I think litigation alone is not going to solve this problem. And so in terms of effectiveness and reality, to Ash's point, I think a lot depends on who is in office. And so if we're thinking about what's happening in Mexico, is Sheinbaum going to be an improvement on AMLO? We'll see whether she is less willing to have her INM officers engage in the kind of behavior that happened under Lopez Obrador. I think there's another election happening somewhere. Someone mentioned that. I'm trying to pretend it's not happening. But no matter the outcome of the US election, undocumented migrants are just going to continue to be the target of vitriol and repression. So we really do need to think about political and cultural angles in addition to litigation strategies. So as I said before, the culture of CBP is a real problem, right, dating back to 2003 when INS was broken up into the enforcement and benefit arms. It's now a real culture of enforcement that I find terrifying. The more I learn about it, the scarier I find. So short of abolition, I think what we need is some serious First Amendment training of officers, right? That's why I talked about training, because people need to get in there and start changing the culture. And they also need to take that training seriously and understand that they're going to face consequences. And I think that's going to be pretty difficult based on what I know of the culture of CBP. It's really, litigation's an uphill battle, so is politics, right? So international law, right? If we're thinking about international law as a solution, it doesn't have a lot of teeth in terms of enforcement, but it can be used to name and shame, right? That could be useful for its expressive function, maybe a special rapporteur on transnational digital repression, or, the UN Human Rights Committee, right, could clarify that they think that border lawyering activities are protected under Article 19, right? There are a bunch of different routes you could take using international law to clarify the law, to issue reports, right? And also when it comes to Mexico, the Inter-American human rights system, right, their government actually pays attention to it, unlike ours. So that's a potential route and involves shaming by, some of its peer nations. And so, whether or not they take that as seriously as pressure from the US, we'll see, but it's one way to go. And then I think we just need to think creatively about what are the other levers, both on the governments and on companies, right? So thinking both about, some of these companies producing spyware, maybe there aren't any levers, but maybe some of the other companies in Silicon Valley, right, are there roles that the corporate world can play in preventing this mass surveillance, right? What else can be done on kind of the technical side, as you were asking Ron earlier?
So I'll just pick up and first address the question of a ban or a moratorium on spyware. I respect a lot of my colleagues and some of the organizations that are advocating for a ban, but I come from an arms control background, and one thing I'm very wary of are rhetorical calls for something like a moratorium or ban when there really is no viable verification mechanism. I think that's definitely the case in this area. It'd be simply impossible to have states agree to this in any meaningful sense. And furthermore, there's a risk it would drive a lot of the technological innovation further underground, making it yet more difficult to verify, which is why I think personally the focus should be on slightly lower level measures that are more practical and realistic. The problem here is, I'll be frank, it's pretty grim. Regulating this space is extremely challenging. I would say there are two inherent conflicts of interest in this space for virtually every government. One is, it gets to what Ashley was talking about with Section 702, which is that as much as, for example, the United States has really led the way in terms of all of these initiatives around digital transnational repression for victims in the United States, it has this posture internationally. So there's a obvious contradiction and perhaps a limit to how far they could go. The second is that virtually every government, and especially the United States, has a dog in this race, so to speak. Every government has well-resourced national security agencies, signals intelligence agencies that want to be very well-equipped. A lot of them have enormous outsized influence within their government bureaucracies. They can invoke the risks of national security to squelch a lot of measures to constrain what they're doing or bring more transparency and accountability. For example, I'll give you from Canada. In the United States, I think interesting measure, an executive order from the Biden administration around this topic was put forward, and part of it has to do with identifying companies that are violators of human rights abuses abroad or present a risk to national security. That's quite a remarkable thing coming from the United States. You don't even need to show that a foreign government used spyware even to engage in domestic repression. It's enough that the firm sold to that particular country that has a bad human rights track record. However, Canada, which has signed on to this statement, has done nothing of the sort. And they're completely opaque about our own law enforcement and intelligence agencies' use of spyware. There's zero transparency in my country. It's very old school British culture of intelligence, which is basically, no one should ask us any questions about what we're doing because you can trust us. Well, that's not the world that I would like to live in. I mean, ideally, you'd want to see states follow and be guided by a framework that comes from international human rights law. But we're a long way from there, obviously. So I think the challenge is to find little bits and pieces where you can move things forward, and that has to come from governments, from civil society, and from technology platforms.
Let me just follow up on one question for you, Ron. So, and this, dovetails with the question that we got through the QR code too. Your paper gestures at the possibility that international law might impose an obligation, or might be understood to impose an obligation on states to protect their own citizens from digital transnational repression originating from abroad. Now, that may not be effective for a lot of states, depending on which state you're talking about and their ability to, influence the behavior of other states. But say you're talking about the U.S. Is there a meaningful possibility that that obligation could actually improve the situation? Could actually protect people from these sorts of abuses, or, to your earlier point, if there's an attacker willing to deploy the spyware, there's nothing that can be done, and no matter what the political pressure happens to be.
Well, it feels to me like what's going on in the United States now around digital transnational repression is a bit like what was happening around disinformation a few years ago after the 2016 election and the pandemic. There was a lot of attention to the subject, a lot of initiatives were happening, some good, some bad. Right now, transnational repression is very au courant, and there's a lot happening. I do think, however, there is this contradiction in principle and practice in the United States, and that presents a limit until that changes to how far things could go addressing it. But clearly there are a lot of people who buy into the argument that they have an obligation to protect people. Notice the language, though. So, for example, right now, I'm sure people have been following this. Canada is involved in a very serious diplomatic dispute with India, and this has to do with the murder of a Sikh separatist in Canada, organized by India and undertaken, by the way, with subcontracting to organized criminal groups. So, a clear case of transnational repression, undoubtedly digital transnational repression as well. But in taking the action that the Prime Minister has taken, the language that's used is very much about a violation of sovereignty, violation of Canada's territory, not human rights. Last thing I'll say about this, as much as I think it's good what is happening, the responses that are taken, the government being vocal about it. Back in 2018, we at the Citizen Lab discovered that a Saudi permanent resident, Omar Abdulaziz, had his phone hacked by Saudi Arabia with Pegasus spyware. We published our report on October 1st. Very next day, Jamal Khashoggi, his close confidant, was murdered. There was not a peep from the Canadian government about that at all. And it was so disappointing to me. If you don't condemn that sort of thing, you're actually inviting it, was my view. And here we are, many years later, and somebody is assassinated in Canada. I think my view is that governments, at the very least, should be speaking out and condemning this sort of activity.
Ashley?
So I think the question earlier had to do with what I'd like to be able to argue on the merits in court. And so speaking from a US constitutional perspective and starting with the First Amendment, for surveillance activities that are capturing information of people in the United States, information and communications of people in the United States or Americans abroad, if those surveillance activities are undertaken in retaliation for the exercise of First Amendment rights, like described in your paper and everything that's happened with El Otro Lado, that's categorically unlawful, period. If the surveillance activities are undertaken and in the service of viewpoint discrimination, if they're fundamentally about discriminating against people on the basis of the content of their speech, those activities should be subject to extremely strict scrutiny. Now, if the government is using surveillance to collect information about people's protected associations, that surveillance needs to be subject to exacting scrutiny, which is a little looser than strict, but still requires there to be real narrow tailoring. The surveillance needs to be tailored narrowly to the government's objective in collecting this information. And then finally, regardless of what the government's actually collecting through its surveillance, if the surveillance is chilling American speech, if it's chilling the speech of people in the United States, at a minimum, it should be subject to intermediate scrutiny, which requires a means-ends fit that just isn't there when it comes to Section 702 surveillance and other forms of foreign intelligence surveillance. And then more broadly, we've been talking a bit about international human rights standards. The Biden administration has put forward some very modest reforms in recent years, including the adoption of a partial necessity and proportionality test in its signals intelligence activities. It does not go far enough. And of course, the document setting forth this test says that this document does not create any rights enforceable in court. But I would like to be able to argue that the government's surveillance activities, even when they're not directly implicating the rights of people inside the US or Americans abroad, still need to be necessary and proportionate.
I want to ask you one more question, Ashley, but I'm going to, we have about 15 minutes left, so if folks have questions and want to come to the mic, feel free to line up. While folks are doing that, let me just ask you one additional question. So there was a sense, especially in the conversation between Jamil and Catherine, after Catherine spoke, that part of the problem, at least when it comes to digital transnational repression, to the ability of actors to reach across borders to abuse human rights, stems from the interconnectedness of our digital world. It's a feature of this globalization, which I think is why Catherine paused when Jamil asked her whether our globalized public discourse is a good thing. But there are some activists who you've worked with in the European Union who are trying to leverage that interconnectedness as a way of applying European notions of privacy, which tend to be more protective here in the United States. So I wonder whether you could tell us about that, and also tell us whether you think that's going to be effective, whether you think that's a promising avenue for importing some more rights protective regime into the United States.
I like that we can continue on this theme of optimism tempered by harsh reality, but optimism survives nonetheless. So yes, it's true. There are Europeans who have really flipped the script or turned the tables on the downsides and the risks associated with this increase in globalization and interconnectedness, which of course is an avenue for transnational digital repression and some of our worst instincts as human beings, but also is a way in which to pressure the US government to enact surveillance reform. So Max Schrems is a great example of this phenomenon of an activist working in the European Union. He's an Austrian privacy activist. And for context here, under EU law, when companies in Europe want to send large volumes of personal data to the United States or outside of the European Union, it's incredibly cumbersome. It's costly, it's difficult, EU law makes it challenging. So in the late 1990s, to facilitate these large-scale data transfers, which are important to our globalized economy, the EU and the US negotiated a special agreement. And that agreement was predicated on the idea that the US provides an essentially equivalent level of protection for Europeans as the EU. This is obviously false. And after the Snowden disclosures, it was very obvious that it was false. And so after the Snowden disclosures, Max Schrems brought a lawsuit against Facebook in which he challenged this special agreement under EU law. It went up to the EU's highest court, which struck down the agreement. It said, this doesn't look quite right. And so then the US and the EU went back to the negotiating table. The US made some completely cosmetic changes, negotiated a new agreement. Max Schrems brought another lawsuit. I provided expert testimony in that lawsuit with the assistance of my ACLU colleagues, including Patrick Toomey, who's here today. And that case went back up to the EU's highest court. It again struck down the special agreement, finding that US law did not adequately protect the rights of Europeans. So after that, the Biden administration's really in a bind here because they're not about to unilaterally, radically reform US surveillance law. Congress didn't seem to have much appetite for extending rights to non-US citizens. But what the Biden administration did was put forward the policy that I referenced earlier. It incorporated a version of a necessity and proportionality standard into an executive order governing the acquisition of intelligence, signals intelligence. And it also created a data protection review court in an effort to make the Europeans happy. Now, this third iteration of the agreement is currently being litigated. It remains to be seen what will happen, but Max's efforts did lead to some reforms here on the US front.
Great. So I think we have a couple of questions at the mic. Go for it.
Thank you, Alex, for taking questions from the bullpen. This is really towards Jaya and Ashley a little bit. You guys have brought up sort of CBP, and to you, Ron, as a Canadian. You guys have brought up CBP.
Thank you.
No problem. Welcome. And, sort of at the border, I know you had brought up some of your clients being questioned. About a year ago, my organization, the Black Alliance for Just Immigration and the American Immigration Council, came out with a report about CBP being at George Floyd protest. I think they were in 18 cities, aerial surveillance, and sort of being involved in these protests. So I was wondering if you guys could speak a little bit to CBP's sort of mission creep, right? Protests are, supposedly protected by the First Amendment. Being involved in these type of activities, particularly when it comes down to citizens and non-citizens sort of, expressing the First Amendment right. Thank you.
Yeah, thank you. It's a great question, and part of the reason I say, the more I study CBP, the more I find it terrifying, and the more you see the stakes of this election in particular, I think, because, it's not unfortunately a surprise to me or anyone who's a student of history that the militarization of the border is going to creep into the interior, and it's going to affect both non-citizens who are protesting George Floyd and citizens who are protesting the war in Gaza, right? So it kind of comes full circle now. I don't know that CBP has been at these protests per se, but it is very concerning, kind of relates to the question that was brought before the first panel about, and I appreciated Alina and Ahilan, the responses you gave that about what best practices might look like at universities for students involved in the protest, but there we have a very real challenge, right, where the terms of your visa depend on you being enrolled in school, and if you are suspended for being engaged in protests, right, that right is going to be gone. So I think, the intersection of immigration and the right to speak is very concerning, and I think I am worried, given the plans that are being expounded in the 2025 plan about what that means if we're going to deport all the undocumented immigrants in the country, and we're thinking about the expansion of CBP in the interior. What that means both for people's physical security, but also for the expression of First Amendment rights for anyone who's a non-citizen, anyone who looks like or sounds like they could be a and I say that with scare quotes, right? Could be a non-citizen. So yeah, the mission creep is very concerning, and I offer culture change, but I don't know that that's enough, and I don't know that that's possible.
Great. So we'll take one more question from the mic, and I have another question that came through on the QR code. We'll take those two, and then we'll be at just about time. But please go ahead.
Yeah, I've heard something that's kind of made me, well, I won't say awake, but a couple of things. Someone mentioned that the hope for the future is in the change of the composition of the courts, which implies that judges do not really follow the law, but follow their own inclination. And furthermore, there was this mention of different kinds of scrutiny, strict scrutiny, intermediate scrutiny. I know that the reasonableness test is usually called by lawyers a mirror test, where if you stand in front of a mirror and manage, after you delivered your argument, to not fall down laughing, then it passed. So the problem seems to me, the number one problem is with the courts and with the real absence of due process when it comes to judicial decision-making process. My personal experience is that judges simply replace parties' argument with their own completely bogus argument to decide cases the way they want to. And I sued a bunch of federal judges for fraud, and their argument is that in a case known as Pearson against Ray, judges gave themselves the immunity in cases when they act from the bench, quote unquote, maliciously and corruptly. So they do a run around the due process. In effect, we are proud of having due process, but we delegate its exercise to people who are not obligated, or say they're not obligated to follow due process. And this way, judging is arbitrary, and that is why you cannot really get anything in the courts. You have to march in the streets, and etc. So my question is really about the press. The press really refuses to look at how courts operate. There is really, it must have been 1,000 journalists that I've talked to, and they all say, no, if it comes to judges, this is a branch of a government we're not going to talk about. They talk about two branches of government, but not about judiciary. So isn't the problem, the root problem is how judiciary operates, that it is not bound by due process?
It's people all the way down. Let me offer one reflection on this question, and then maybe turn it over to Ashley. So it's interesting to note how in a number of important cases, either in this area or in closely related areas where you're dealing with national security, a flip of one vote could have actually made a pretty significant difference. So, the case that was mentioned that Jamil litigated up to the Supreme Court, that resulted in a decision a few months before the Snowden disclosures. Amnesty versus Clapper was a 5-4 decision on standing. And so, if one justice had voted the other way, and there was good reason to think at the oral argument that it might have come out the other way, if one justice had voted the other way, we might have had a different rule on when challenges could be brought against secret surveillance programs, and maybe even surveillance programs that relied on sophisticated spyware. So actually, if Clapper had come out differently, would your world be different? Ron, would you have more hope in the courts to adjudicate these kinds of cases? Or would we still be dealing with the issue that you later ran into in the Wikimedia case with state secrets? Would that have been the next hurdle? You would have cleared the first hurdle, but there would have been another one just ahead that would have tripped you up.
No, it's a great question. I like this counterfactual. I do think things would be very different if one vote had flipped in the Amnesty case. State secrets would still be a hurdle. In the Wikimedia context, though, it was the nexus of the two. It was the state secrets and standing question. But even if standing hadn't been in the picture, would state secrets have been a hurdle? Yes, but again, hard to say. Things would be different. I think the First Amendment basis for standing might have changed things too, and maybe there would have been a focus on the First Amendment claims absent the state secrets privilege. But I do want to underscore, I don't think that judging is entirely arbitrary, and especially in this space, the way courts approach surveillance issues does not fall neatly down partisan lines.
Well, if Clapper had come out differently, at the very least, the civil procedure bar wouldn't be mad at Jamil. So the last question comes from a digital submission, and this one for Jaya. So the question, I think, has to do with the way in which the government characterizes the work of al otro lado. I think the question is asked whether the difficult issue is that the government thinks it can surveil their work because they believe that by providing information to migrants or facilitating the circumvention of the immigration laws, whereas in reality they're providing legal counsel, and if that narrative were more widely accepted either within government or by courts, maybe the legal case would be stronger, the First Amendment case would be stronger. Do you think that's right, and how can that case be made?
Yeah, I would agree with that characterization, and it's the problem that I was referring to before. I come at this from a migration angle, and the smuggling and trafficking laws that come from international law just take a carceral approach to migration. So everything gets painted with this very broad brush, and certainly there are bad actors who, engage in violence against migrants and others. But what it means is that facilitation of movement can also be brought under that brush and characterized, right, as being engaged in illegal activity. And that's also when you invoke the government might be able to invoke this national security exception to the First Amendment. So that's of real concern, and certainly part of the solution is convincing the government, and frankly, I don't know that the Harris administration is going to buy into that any more than the Trump administration from what we've seen so far. And also the general public, right? Because I think, right, there's this feeling that, these people on the border, right, they shouldn't be coming in when actually many of them have a legal right to come in and have their asylum claim heard and determine whether or not they're allowed to stay. But that is really a challenge that we're facing right now, I think, as immigrants' rights advocates. Like, how do you get that message out that this is about enabling people to find safety and freedom, right? Isn't that what we're supposed to be about as a nation? Enabling people to find a country where they can come and express their political opinions freely, where they can engage in dialogue with other people, and not fear violent retribution. So, on that cheery note.
On that aspirational note, let's end. Please join me in thanking our panelists, especially Ron for hazarding the U.S. border to make it here today.